Thank you for joining us for today's webinar, which is an update on employment issues as Ontario reopens, presented by Miller Thomson LLP. My name is Allison Mitchell, and I'm part of the Greater Kitchener-Waterloo Chamber of Commerce team. Before we start our webinar today, there are a few housekeeping items that I would like to share. Your microphones should be muted. If you could please double check to ensure that they are to reduce background noise, we would appreciate it. Please feel free to ask questions throughout the webinar, and you can do so by typing them into the questions box in your control panel. Our presenters will be answering your questions at the end of their presentation. Following today's presentation, you will receive an email follow-up with a link to the recording for today's webinar. Our presenters today are Seann McAleese and Evan Campbell, partners with Miller Thomson LLP. Seann McAleese's specialty is management side labor and employment law, both in the public and private sector. Seann has extensive experience in a variety of industries in both union and non-union settings. Areas of expertise and advice relate to guiding clients on labor relations, union organizing, employment law, executive contracts, restrictive covenants, business transactions, privacy, occupational health and safety, and human rights. Evan Campbell provides proactive advice and representation to employers regarding all aspects of labor relations and employment law. Evan assists employers with a variety of issues, including discipline and terminations, employment standards, corporate mergers and acquisitions, human rights, employment contracts and workplace policies, workplace safety and insurance, health and safety, and industrial and construction labor relations. Seann and Evan both live in Kitchener and primarily practice out of the Kitchener-Waterloo office. I would now like to invite Seann and Evan to begin their presentation.
Thank you very much, Allison. Appreciate it. And thank you to everyone who's joined us. Looking forward to providing you with sort of the latest on what you'll need in order to have a smooth ramp up in your business and return to work. As Allison mentioned, by all means, sort of send some questions our way through the text box. And they'll sort of be collected and we'll respond to those as best we can at the end of the presentation. In terms of the agenda, we're going to cover, as I said, sort of 4 key areas. One is how to administer recalls and reintegration, and how to mitigate constructive dismissal risks. And there's still some, notwithstanding the government's recent legislation, we'll cover that. How to manage work refusals in the event that somebody is refusing to report to work, either for health and safety reasons or potentially just a preference to work from home now. So we'll deal with that. Lastly, we'll deal with occupational health and safety obligations and what you need to do to meet those in the context of COVID-19. And the way we've structured this, and you'll see as we move through the presentation, all of this is sort of interrelated and interdependent. We have to do a good job of this on each step as the employer, and that will set you up for success for the following step and so on. And lastly, at the end of the presentation, we'll just give you the latest in terms of what we know on the return to work front, legislation and updates. And I'm going to pass it over to Evan now, who will take you through administering recalls and reintegration.
Thanks, Sean, and good afternoon, everyone. So we're going to start with speaking about the recall and reintegration process. And the first question we need to consider when we're talking about the recalls is when you as an employer have an obligation to recall your staff. And so many of you likely heard of the government's recent amendment to the infectious disease emergency leave, which is a mouthful, and we use the acronym IDEL. And this was expanded by the government to address a number of potential risk factors for employers and ultimately gives you some additional flexibility in terms of your staff. So I want to touch on a number of the changes which are relevant to you as you're considering recalling your staff. So firstly, the government changed the leave so that non-unionized employees who were placed on a temporary layoff are now deemed to be on this unpaid leave. And this has the benefit of it eliminates the automatic terminations which would occur under the Employment Standards Act if employees are on a temporary layoff. So many of you likely laid off staff in March or April when the pandemic was happening. And if the government hadn't amended this leave, your obligation to recall them likely will be coming in the next few weeks. given the timeframes which are mandated by the Employment Standards Act. So this amendment by the government essentially takes away the potential for those layoffs to turn into automatic terminations, and therefore you do not have to recall them or have this termination payout. So again, it gives you some more flexibility as an employer to essentially delay recalling staff. Now, from a time period perspective, this amendment is from March 1st, 2020, and essentially goes onwards until the state of emergency is revoked by the government and 6 weeks thereafter. So if we go off the time frame, the government recently changed the state of emergency until the end of June. We have 6 weeks thereafter, which brings us to August, before we're going to have those obligations to recall. So again, a good news piece for employers, gives us some more flexibility in terms of not having to recall individuals within the next few weeks or face potential significant payouts. So important to note when you're engaging in your recall planning. Some other important changes by this EIDL amendment. Firstly, this provides that any future changes in terms of a reduction in hours or putting people on, ceasing all hours of work automatically results in those employees being placed on this EIDL leave. And the regulation also touches on this risk of constructive dismissal, which Seann is going to speak about. But many of you likely saw the news articles from various lawyers which talked about a layoff can constitute a constructive dismissal. And so the government, likely seeing that potential risk in claims against employers, included a provision under this regulation which provides that a layoff does not constitute a constructive dismissal, and so thereby reducing the risk. Now, there's lots of talk among us lawyers about whether this addresses the potential for employees to bring a claim in court and allege a common law constructive dismissal, which is different than asserting a dismissal under the Employment Standards Act. So there's still potentially some risk, but this also is a good news piece for employers and most definitely reduces the risk of those claims. The last piece about this EIDL regulation is that it is a job protected leave. And that implies, similar to other job protected leaves under the Employment Standards Act, that there is a right of reinstatement, similar to a maternity leave or other job protected leaves. And so there's some additional risk if we're engaging in terminations. Doesn't mean we can't engage in a termination. However, the reason for the termination must be completely unrelated to the leave. And so additional factor to consider when you're assessing potentially recall or termination. So big picture in terms of your recall piece is being mindful that you may not have to recall given this extension of the time period within which you can keep people off work. So when we move on and we get to the question of, okay, we want to recall staff, maybe operationally we have some specific needs, it's important to note that employees have a contractual obligation to return to work. And this means that employees are required, unless they have some pretty specific and valid reasons to refuse to return. Now, those reasons to refuse to return can include human rights accommodation requests. It can include a valid work refusal under the Occupational Health and Safety Act. Of course, public health orders can also come into play when we're assessing that. So the employee can't say to you, I don't want to come back to work, because that can be a job abandonment. But if they say to you, I don't feel safe coming back to work because of I'm concerned about X, Y, and Z, that can trigger an additional requirement for you as an employer to engage with that employee. Similarly, if the employee says, I don't want to come back, or I'm not able to come back because of childcare obligations, that can form a valid reason. And one of the examples we threw up on the slide here was fear of using public transit to get to work. And I think we can all expect that employees are going to push back, and they already have. I have a number of clients who are engaging with staff who are pushing back on returning. So the question is this a valid reason to refuse to return to work? And like most lawyer questions and answers, of course, there's some gray area. A general fear of just saying I'm too scared to use public transit is unlikely to be a sufficient reason to refuse to return to work. However, if that same employee provided you medical documentation which substantiated mental health condition or other medical condition which had a valid reason why they couldn't use public health, or public transit, for example, significant and diagnosed anxiety as a result of the public use of public transit, that can form a valid reason. And so all this to say is you have a general right to request employees to return. And of course, there's layers of complexity depending on the employee's response. Some practical tips when we're talking about recalling staff. Of course, you want to ensure that they're properly recalled. In Ontario, under the Employment Standards Act, there is actually not specific prescribed format which must occur to recall an employee. And we put up there a good example of Alberta. And under their applicable employment legislation, they do have some pretty specific requirements. It must be served on the employee. The recall notice must be in writing 7 days before the recall date. And we put that up there just as some good practical tips in terms of your recall. Obviously, have it in writing. Make sure the employee gets it. You can confirm they received it. Give them as much notice as possible before they return. And also within that recall letter, we would recommend specifying all the good things you're doing to ensure that the staff are safe. This is obviously a heightened time when everyone's particularly nervous about returning to work. And so putting in your recall notice some of the items you're doing to ensure a safe return to work is proactively going to address their concerns. And it's also going to place you in a good defensible position should they refuse to return to work. So we're proactively addressing both the employee's concerns, but also the legal risks of when we force people to come back to work. So if that employee says to you, I'm scared because of X, well, if you've already addressed that in your letter, you're proactively dealing with those concerns on the front end as opposed to having to, respond to concerns by employees. It's also going to help you if the employee does assert a work refusal and you are engaging the Ministry of Labor to say, hey, here's our recall notice, here's all the things we already told the employee about how we're doing X, Y, and Z to ensure a safe return to work. And again, it has a practical benefit of, encouraging people to come back versus kind of the hammer. And we've referenced here the notion of specifying that if the employee doesn't return, that they forfeit any termination and severance pay entitlements. And so depending on your specific workplace, you may want to include that in your first notice, you may not. But I think as employers, we need to be mindful again that employees are likely extra heightened in terms of their response to these notices. And so my recommendation likely in most scenarios is going to be take a soft approach, outline their return, outline the dates, outline all the fantastic things you're doing, how you expect them to return. If they don't return on a specified date or they don't get back in touch with you as the reason, you're going to send a further notice specifying if they don't get in touch with you, it's an abandonment and therefore termination severance pay. So work specific, work location specific in terms of whether you include that or not. But I think as employers in these types of scenarios, which obviously are very unusual, likely best to not have that in your first letter and save it for your follow-up if they don't return. One of the questions that we're getting currently, and I'm sure many of you are considering it, is terminations as opposed to recalls. And this can arise where you've realized you simply don't need as many people as you had. And you've been running on a leaner operations, and you've realized through that, as many employers have, well, we don't need 50 people, or actually only need 40 to do the exact same number of work. Or alternatively, the operations are such that you simply cannot recall staff, and there's no foreseeable likelihood that you'll be able to recall staff this year due to your type of business. And so some considerations, some practical considerations when you're engaging in that, terminations or calling, however you want to describe it, Be very careful of the potential ramifications of an employee asserting a human rights code claim, or alternatively under IDEL, we mentioned this is the job protected leave. So for example, if you've had 40 and you're maybe getting rid of 10, and the 10 individuals ultimately selected for termination are the oldest of the 40, you're going to likely have a claim by at least one of those or all of them asserting this, discrimination based on age. Or similarly, if you had 10 employees and you're not recalling 5, but those 5 are the ones who have a history of potential work injuries or WSIB claims, clearly you're likely setting yourself up for a potential claim. So one thing to consider if you're engaging in this exercise is to develop some objective criteria. And things to consider, obviously, your seniority, qualifications, maybe operational flexibility. Can the person do multiple positions within our more lean organization? Obviously, past performance. But the most important thing, whatever you assess, is that you have an objective basis as to why that person was selected for termination. Therefore, if that employee challenges a termination and says, well, you dismiss me versus someone else because of my previous medical history or because of my age, you can say, no, we selected you for dismissal because of X, Y, and Z. You're the least qualified. There's some performance issues. Here it is. So I think be mindful now when you're engaging in this assessment of putting yourself in a good, defensible position if that individual or multiple individuals challenge the fact that you terminated them versus engaging in the recall. And that will also meet your obligations under IDEL to defend any assertion that you're terminating the individuals due to the leave. Beyond terminations, obviously, if employee does not return when you've requested the return, that is a job abandonment. But be careful of jumping on it and they don't get back to you on that first notice. As I mentioned, you're going to want to send a follow-up notice, even if you include in your first letter to say, if you don't come back, we're taking the position, you're abandoning your job, and you're foregoing any termination or severance pay entitlements. You're still going to want to follow up again, because we don't want to be in a situation where that employee says, well, I missed that letter, or I didn't check my mailbox, or I didn't check my email, or whatever excuse they have, and they want to come back. So it's important to follow up before you assert that abandoned position. Or they may say, I've had this medical condition, which is why I wasn't able to, and you jumped on it, and now I'm not only did you terminate me, but I'm asserting a human rights claim on that basis. So you're going to want to follow up if someone simply does not get back to you or doesn't show up to work. Some practical things to consider as you're engaging in your recall and more so reintegration plans of staff. Of course, again, many staff members are going to be concerned about coming back to work, and particularly on a full-time basis, especially if they're working from home and you want them back in the office. So things to think about are gradual increase in hours, increase in days, modified schedules, splitting work from home or from the office to get people accustomed back into the workplace. And that may also have an important benefit in terms of your larger COVID planning to ensure a safe workplace under the Occupational Health and Safety Act in terms of having less people within your office. But again, being mindful of how the employees are going to respond. And if this is something you're doing, again, putting in your recall notices that, hey, these are the steps, one of the steps we're taking to ensure a safe workplace and ensure a safe reintegration and effective reintegration of all staff members. But of course, we got to be mindful of every risk. As lawyers, we always consider the risks. And so if we recall an individual who is off on a layoff or now IDEL, who's simply not working, and we then reduce their hours or reduce their compensation, of course, that reduction, depending on how much it is, can constitute a fresh basis for that individual to search a constructive dismissal. And going back to our discussion earlier about this notion of constructive dismissal and how many lawyers were writing about it and how it was a big issue, but the reality on the practical basis is that most employees were simply happy they had a job, even if they were laid off. In terms of my practice being solely management side, I didn't see a significant number of claims by employees asserting a constructive dismissal in response to a layoff. And I think that was partially the mood at that time. But of course, things are quickly changing. People's views may change. And so while they may not have asserted a constructive 2 months ago, they may now if you give them a basis by giving them a fresh ground. So we have to balance your operational needs, your COVID reintegration plans versus the potential risk if you recall Johnny, but only have him working half his time, is working half his hours, making half the amount of money. Obviously, there's potential that he will assert a claim. So a risk factor as you're engaging in your overall recall planning and reintegration planning. Once you get people back, or even now as you're planning this, some other important things to consider, of course, vacation. You may have allowed employees to use vacation before going off, or alternatively, you have employees returning who haven't used hardly any vacation. So you need to think about that now. Sorry, I was looking at a note in terms of hearing me. You may have employees who've banked a significant amount of vacation. So, things to consider are dealing with that now, so you don't have employees who are using a significant amount of vacation in the fall or around Christmas time. So just mapping that out now. And remember, under the Employment Standards Act, you do have a right as an employer to unilaterally schedule vacation. Of course, employees hopefully will agree in terms of scheduling their vacation on a go-forward basis. But again, just thinking about your own operations and being mindful of, we don't want all of our staff or the bulk of our staff trying to take vacation in October or November if the world kind of reopens up more than it is now. Other things to consider, obviously, are contingency planning, doing that now, being mindful that there's going to be more leaves likely by staff when they return. I think that's also really important when you're considering how many staff members you need to return. So I think you should assume as an employer that your staff are not going to work at the same productivity level they were obviously pre this. And so while you may say, okay, we only need 10 people, I think you need to be mindful that you may need more because those 10 are going to be off more. They're going to, if anyone has any type of illness, they're going to take time off, rightfully so. There's going to be more likely accommodation requests. And so you may need extra bodies to do the work of the 10. So I think something to consider now while you're engaging in this assessment of how many staff do we want to recall, do we need on a go-forward basis. So passing over to Seann to talk about some constructive dismissal risks now.
Thank you, Evan. So we're going to talk about in the event that you are presented with constructive dismissal complaints or something short of it, people obviously just objecting to what you're proposing in terms of cost saving measures or other items. So, and again, as everything that sort of Evan set out in his piece will help inform this as well, because obviously the more detail you provide employees, then there's less uncertainty, and it's always in a vacuum of uncertainty where these types of issues arise. So, you're going to get certainly claims, and I've sort of tried to put them in, the major ones will be, if there's a gradual increase in work and pay is going to sort of follow that gradual increase, so it's not going to be 100% of pay at once, then, that's a potential, right? I mean, we always operate with this sort of assumption, based on a case law generally, that any 10% or more of a reduction in someone's compensation may on its own trigger a constructive dismissal risk. So, and many employers have implemented wage cuts, and some have implemented hours cuts, which in turn they prorated salaried employees to match the hours worked. So there is that risk on the basis, on sort of a go-forward basis. Now, we do have some protection from the IDEL that Evan mentioned, because it speaks to not only if you're out on a layoff entirely, but it also speaks to a shortage of hours, which in turn would mean obviously a shortage in pay. And it deems such circumstances, if COVID-19 related, to not be constructive dismissal. And whether that applies to the common law, again, we don't know for sure, but it certainly strengthens our argument that it would not be a constructive dismissal to sort of gradually increase hours and work in order to meet the employer's needs and to remain in business and to keep its employees gainfully employed. So, but that's an area where you're going to need to think about it. For those of you that have people that went out on layoff before March 1st, for example, or frankly, that are on layoff even after that and arguably protected by the IDEL, if you haven't received constructive dismissal complaints from these folks already based on being laid off with $0, there's a solid argument that they've condoned what's occurred. So even if you didn't have the contractual right at the front end to do layoffs, you're probably safe on that front. So I think you can, if you haven't got any complaints or claims, you're pretty safe at this stage. So what you've got to worry about is the go forward reintegration process. Another thing for you to consider in terms of mitigating that risk for constructive dismissal, especially if you're looking at a graduated return, is think about the federal work-share program. So, if employees give up, a percentage of their work so that others can work and everyone's sharing the available pool of hours, then their shortfall in wages can be topped up by the Employment Insurance Act system, and that's useful because it's the federal government's money that they've paid into, that you've paid into, that's used to top up, and that will also help obviously mitigate the constructive dismissal risk because they're losing less pay than if you didn't apply for the program and just simply said, sorry guys, we only have 3 days a week for you and we're going to prorate your pay accordingly. So that's something that's definitely worth considering for mitigating constructive dismissal risks. And they seem to be, approving those fairly steadily when you apply. And it's a fairly straightforward application process, but you do have to have employee buy-in or union buy-in if you're unionized. So there is a process to go through, but it's fairly straightforward. The other obviously avenue that you could access would be the Canada Emergency Wage Subsidy, which the government appears to be extending out through into the fall, and who knows, because frankly a lot of what we've seen is sort of back of the napkin planning by the federal government. So it stands to reason that subsidy could be available in some shape or form for quite some time. So that's absolutely worth considering in order to mitigate your constructive dismissal risks. Another way to approach this would be to consider a retention bonus, because there is a lot of uncertainty, and if you have good employees that may be able to go elsewhere and work full-time hours or earn more money, and aren't inclined to be patient to see whether or not things return to normal at your particular workplace, then consider whether you say to them, look guys, you end of the year, if you're still here at year end, we'll provide you with a lump sum payment of X. X might be $1,000, it might be $5,000. It really depends on how important that particular employee is to your organization. And the other thing that you could do is, if you go the retention bonus route, is you could sort of build in an acknowledgement and a release that, look, you understand that we're not going to be able to maintain your hours for a bit, or that you're going to suffer a loss of income. But in exchange for this payment and your commitment to hang around, you're not going to sue us for constructive dismissal. I mean, we would word it a little less abruptly than that, but that's something that you could attach to that. The other piece that you may think about is sort of a gradual change from the home workplace, if they're working from home, to the workplace proper, and provide an opportunity for them to, maybe it's 1 day a week for the first 2 weeks, and maybe it's 2 days a week in the office, and then 3 days, and then 4 days, and just sort of a graduated increase so that you can siphon them off the work from home. And frankly, as they start to see that you've implemented the OSHA related obligations that will cover as Evan said, put that in the recall letter so they know up front that you've engaged in significant efforts. And like I said, we'll cover those shortly. And make sure that you update employees periodically, and that you're following public health advice, and so that they understand that you're on top of it, and will continue as the employer to take every precaution reasonable for their protection. Another piece, apologize, there isn't a bullet on it, but this isn't a critically important thing for you to think about. I know a lot of our HR client contacts are sort of just trying to keep their head above water with all of this change. But when you do have 5 minutes, you're going to want to think about amending your employment offers. So make sure that your employment agreements or your employment offer letters have the magic wording around you acknowledge and agree that we have the right to lay you off in accordance with the Employment Standards Act. And then with that simple phrase, you mitigate any future risk. And maybe it's the second wave of COVID, maybe it's some other or some other something that comes along. But if you have that wording in your offer letters, then you don't face this uncertainty, and it won't matter whether or not the government solution through the IDEL covers you adequately or not. So certainly think about that. And the other thing that you'll need, and some clients have been incorporating this now, given the uncertainty, especially again if there might be a second wave, is include in your offer letter the ability to defer the start date, or to potentially even rescind the offer in the event that situations deteriorate significantly. Because in the absence of those things, if a conditional offer of employment is accepted by the applicant and there's a start date in the offer letter, and you try to push that start date back or you rescind the offer, there's a lot of bad case law out there that says, they get treated as though you were the employer terminating them from their prior employment. So basically you inherit a wrongful dismissal claim, even though they've never worked for you a day in their life. So those are two critical things that I would recommend you include. Next slide. Now we're going to turn our attention to managing those employees that do refuse to work, and there will be those employees, and we're seeing that now with some of the advice we've been giving to clients. It's a real issue, and again, what you do in the prior two steps that we've covered, or prior two areas for employers to manage, is what you do in that process will set you up to aggressively manage any refusals. Because if you've shown that you have OSHA obligations well in hand, you've communicated that to them, you've tried to work with them in terms of graduating their return back to the workplace, all of those things will help you manage these sorts of refusals. Especially the first bullet, which is what I anticipate most of what you'll hear, which is there's just a perception that it's unsafe, or they're just fearful that it's unsafe, not wanting to come to take public transit, not wanting to go in an elevator in a confined space with other people in order to get up to their office space. So they could simply be based on those fears, if I can put it that way. And again, if you've articulated to them before they even step foot back in the workplace how it is you will manage their concerns, then they have less of a basis to raise in the first place. And if they do raise it, you can point to objective measures that you've taken as the employer to manage those concerns. I think you will also see the media is all over it, surveys and such, and the office is dead, and grand pronouncements like that, which I think are obviously exaggerated. But in any event, there's a real push and affinity for work from home as the solution to a lot of this stuff. But it's not a basis to refuse to report to work. You can't say, I prefer the home environment. That's what I want to do. You could certainly insist as the employer that you need to report to work, and you may have to sort of engage in a escalating cautionary letters, threatening discipline in the event that they don't report to work as required, because the preference has no legal effect. But what you will see for those folks, probably they're going to say, oh, it's due to childcare, which, as you probably all know, as of Friday in Waterloo region, daycares are permitted to reopen, last Friday that is, obviously with protections and things that mean that, the volume may not be there initially, but part of that problem should start to resolve itself. But you'll hear that as a basis for refusal. I don't have childcare, or I'm immunocompromised, or somebody else in my home is, or they have comorbidity factors that they've seen, such as diabetes, seems to be highly related to fatalities that relate to COVID-19. So you may hear those sorts of things. In those cases, you'll have to manage it with requests for medical information, or requests for what efforts have you engaged in to locate alternative childcare. You really have to sort of push back and not make it automatic, because you've got to concern yourself with a precedent. If you start to grant these, then it's going to be more difficult to deny it for other folks. So, so think about that. And when you're, as part of that communication exercise in assuaging their concerns, try to rely on public health materials. Employees will see that as neutral, unbiased. That will help to give them a bit of a comfort level in terms of what it is you're doing and that you're compliant. So certainly try to rely on those, because a lot of this is going to be managing employee perceptions as much as anything else. Next slide, Evan. In the event that you are aggressively managing a case, make sure that first, is there a protected ground? Like, are we dealing with a preference or, somebody that just wants to stay home or doesn't want to come to the office? Are they a part-time employee and they're making more money on CERB? We're going to encounter things like that. So, you're gonna have to look at them case by case. You're not just gonna say you refuse to everybody, then you're terminated. If there's a protected ground, such as I said, if the employee themselves is immunocompromised or they have a psychiatric high anxiety disorder that may be triggered by, requirement to report to the workplace. I mean, you're gonna have to get at that. You're gonna have to consider that independently and go down the road of, they've got to establish that obviously through medical information and other things. But you're gonna have to, as I said, go through those efforts. If it is an individual who, just doesn't want to come back yet, or like I said, you have a graduated return, there's certainly no harm in, treating people individually, even if it's not legally required. Now, it's obviously more of an HR function as opposed to a legal requirement, but, certainly give that consideration. But you're definitely going to have to be mindful of which leaves you grant and don't grant, and make sure that there's a legitimate basis for us to distinguish in case you're challenged. Next slide. Now, in the event that you engage in the individual analysis and the medical's not there, or it turns out after further investigation it's merely a preference, or they're not engaging in efforts to find alternative childcare, and they're not reporting to work, then unfortunately, if they refuse and they say it's my health is at risk, if they're in that category, then you're kind of pushed down this one path, unlike those others. If it's I can't report to work because it's unsafe, then you need to go through the Ministry of Labor work refusal process, and that would include contacting the Minister of Labor. And there's 3 steps basically that you go through in terms of managing the work refusal process, and basically putting it to the employee at each step that, okay, we've satisfied this rung of the test, you've got to come back, and then you contact the MOL. The MOL investigates, and you'll see the note there that all 200 up until April, according to the Toronto Star, they denied any sort of order and rejected the employee's claim that it was generally unsafe due to COVID-19. So you got some decent backing from the MOL on that. If they refuse after the MOL says all clear, then you're dealing with escalating discipline, and it's basically another form of insubordination, and you've got to caution them about the consequences if they don't return to work, and sort of go down that road. You are going to want to make sure, though, that you have a significant paper trail on this, and documented safety, obviously, around your OSHA obligations, because I think the courts and tribunals, if we're tested on this through litigation from terminated employees, they're gonna be sympathetic to employees, right? So we're gonna have to definitely be able to position to show that you made every effort reasonable to try to assuage their concerns, and that you've satisfied the ministry and you've satisfied OSHA, and that will put you in a good defense. And I think now it's over to Evan, who's going to sort of outline what it is you need to do to meet your health and safety obligations and set yourself up for success on my last point. Evan?
Thanks, Sean. So as Sean mentioned, this is kind of the last piece of the puzzle to ensure that we have a successful recall reintegration, which is meeting your obligations under the Occupational Health and Safety Act. And under that act, as many of you likely know, you do have a positive obligation to ensure a safe workplace for all staff. And in terms of COVID, obviously there's heightened responsibility in terms of the workplace. So some practical tips here to consider when you're engaging in this assessment. And obviously it's really important that we do this as soon as possible. So if we're recalling staff the next few weeks, we need to be putting plans in place, if we haven't already, as soon as possible to get that ball rolling, beginning the planning, collecting PPE, etc., to ensure a successful return. So if you haven't begun this process, I would urge you to start as soon as possible. So point one, have a team. And so depending on your operations, that's going to dictate really who needs to be part of this team. I would suggest it be different than your joint health and safety committee. Your COVID team, you're probably going to want to have a little more flexibility in terms of who's on there, in terms of likely senior members of your team, because there's both health and safety considerations. There's also practical operational considerations. And your health and safety committee is an important part of overall safety in the workplace, so they can play a role in this planning. But I think from a general planning process, having a dedicated team is something I would recommend. And part of that process is likely to be consulting experts. That, of course, is your legal counsel in terms of your legal OSHA requirements. That may be, depending on your workplace, having industrial specialists who can give you some suggestions in terms of how to properly operate in a safe environment, because the practical considerations that you really want to think about based on public health directives include, your layout of your staff, of your office, and that may need getting experts to help you engage in the best layout. Of course, some practical things: one-way routes around the office, washrooms, and ensuring that there's one person going in, shields, reorganizing, if you have an office, reorganizing desks, maintaining that 6 feet of separation as much as possible throughout the workplace. And so there's both the physical necessary changes likely to your office or for your facility. And then, of course, there's the return to work planning of, okay, well, how many people are coming in at once? Are we staggering shifts? Are we having a gradual increase to decrease the amount of people returning at once? All of that factors into ensuring you've met all of your requirements to provide a safe workplace. Some other things to think about, of course, conferencing, depending again on your office environment or your workplace. Sometimes conferencing is an important element. You're obviously going to think about that, engage in technology to facilitate those on a go-forward basis, likely. Depending on how much you're interacting with the environment, that's going to increase the risk and may impose additional obligations, depending on also the location you're in. So if you're in Wellington County with the recent face mask requirements, if that comes into the region of Waterloo, we may see additional requirements in terms of, are you engaging with the public? What does that mean in terms of your specific office your specific work environment? Cleaning, depending on, are you retaining a third party, talking to them, ensuring that they're engaging in proper, robust cleaning of the facility on a regular basis, also around touch points. And of course, HVAC systems, filter, pure the air, purge the air on a nightly basis. That may mean talking with your landlord, what is going on in terms of the larger building to ensure a safe workplace. So you really need to engage in a robust assessment of your office environment or your facility, your manufacturing, try to identify the areas of risk and then address those risks to ensure that employees are returning to a safe environment. And as we mentioned, engaging in this assessment now, this robust review of the workplace, putting a plan in place, potentially having, for example, a COVID policy which addresses some of the changes, communicating all of these steps you're taking to the staff before they return is going to likely increase the likelihood they're going to want to return, but it's going to proactively prevent work refusals. And if they arise, you're going to have an objective basis to respond to those concerns. It's also important to note that employees have obligations within health and safety, and there's specific obligations under the Occupational Health and Safety Act for employees or supervisors and, of course, employers. And so if you have specific requirements under a policy or procedure guidelines in terms of COVID, such as physical distancing or PPE, such as face masks, and an employee is simply refusing to engage in that, while they're breaching their obligations, and that arguably can constitute insubordination, and so they need to be disciplined. And it's important within a health and safety framework that we are disciplining employees if they're refusing to follow proper procedure. And that's beyond COVID, that's just in the general workplace, because that ensures that we're meeting our obligations and we're meeting, we're going to be able to substantiate that we've done everything possible. Because oftentimes, and again, beyond COVID, if we see a workplace accident, and Sean and I do a fair amount of OSHA work, and so if we're representing an employer who's been charged for failing to comply with the act, even if we have the most amazing policy, the best COVID policy, and everything's online, well, if all the staff aren't following it, it's worthless. But if we can show that, yeah, Johnny's not following it, we discipline them on a regular basis, they fail to follow it. If someone does get sick and we're charged, that helps us establish that not only do we have the awesome policy, but we've done the training, we've disciplined, etc. And of course, you can only discipline an employee who's aware, who's been trained. And so that's an important element of this as well, is, again, going back to step one, communicating with the employees about the expectations, about the things you're doing, providing necessary training if there are new procedures in place, and then if they fail to do their end of the bargain, imposing the appropriate discipline. So just some high-level OSHA things to consider, and I would recommend you go on the government website. It has some fantastic resources about specific industries, and so that's a good starting place if you're thinking, oh my, this is such a massive issue. Start there. There's very good things to consider, and that will head down the right path in terms of how you ensure that the workplace is safe. So Sean, I'll pass it back to you to touch on some of the most recent things that may have come up regarding COVID and return to work.
Thanks, Evan. Yes, so as you all know, we're in phase two, we being sort of Waterloo region, and frankly, everything except Toronto, Peel, and Windsor are in phase two, which started June 12th. And essentially that sort of allows a lot more businesses to operate. Now, the key thing is you've obviously got to be mindful of the health and safety related obligations. And as Evan mentioned, the Ontario government itself has put together some good resources. You'll see that on this final slide deck here, covid19.ontario.ca. And they've developed industry-specific health and safety guidelines. So we'd certainly encourage you to have a look at those. The Canadian government, same thing. Of course, our firm itself, we track nationally, but obviously that includes Ontario. Any and all developments related to COVID-19, and you'll see it sort of divided into different practice areas. So on the labor and employment side, you'll see the things that relate to health and safety, and constructive dismissal, the layoffs, recall, all those issues that are sort of driven by COVID-19 realities are in quite a bit of detail. In terms of the absolute latest, I sort of mentioned it off the top. His daily press briefing this morning, Prime Minister Trudeau indicated that they're going to extend CERB. It wasn't clear to me how far. It's not a done deal yet. I do believe they have to get Parliament's approval for it. But as I said, I think could be problematic for some employers. I've actually had an arbitration last week dealing with this issue for a client where it seems to be that part-time employees that didn't have any issues reporting to work prior to CERB being introduced suddenly do have issues which prevent them from returning to work. So I mean, obviously, employer side counsel, we're cynical. We tend to deal with the problems. And I'm not suggesting obviously that all part-time employees are like that, of course, but there are some that's a disincentive for them to return to work. So if you do rely on part-time employees to a significant degree, be mindful. Periodically and change quite sporadically. So sort of stay tuned, and the Miller Thomson resource there will keep you up to date if you just want to check that on a daily basis. It's updated daily. So with that, we will turn it over to Allison, who may have some questions to from the group. We're happy to entertain, and we appreciate your time, and we hope that you've learned something that will assist in getting your businesses back up and running. All the best.
Great, thanks so much, Sean and Evan. We've got about 9 minutes left, and we do have several questions, so we'll try and get through as many as we can. So the first question, does the elimination of the automatic terminations also apply to federally regulated companies?
No. So yeah, so that it's provincial legislation only, so it amends the Employment Standards Act. If you're federally regulated, then it's Canada Labor Code. So, and I'm not aware of any amendments to that. But again, if you have a look at the MT COVID Hub, you could probably find some answers on that. But unfortunately, no, it will not apply to federally regulated.
Okay, great, thanks. Next question. What will happen after the 6 weeks after the emergency order is lifted if the employer is not prepared to recall their employees yet? The emergency leave expires 6 weeks after the emergency order. Will we be able to do layoffs then?
Yeah, well, once the IDEL expires after the 6 week point you mentioned, then essentially it would flip back into the layoff world. So if you had laid people off, just to give you an example that'll cover everything, prior to March 1st, which is the date everything gets converted to IDEL, let's say they were laid off 2 weeks before that, then they went to IDEL, and then when IDEL's over, you would have another 11 weeks to get to 13 before the termination would result. So it's basically suspended the clock on layoffs.
Okay, great, thanks. Can you reduce an employee's salary to the maximum allowed under the wage subsidy?
Well, you can, in the sense that the federal government hoped that people would provide the balance, right? The employer would pick up the 25%. It's not a requirement to do so, but again, you still run the risk on the constructive dismissal side, right? Because if you're only paying them 75%, they're short 25, so you still do have that risk, and that's why if you can avail yourself of it and then maybe top it up to 95 or 90%, then you're pretty safe.
Okay. And with the Occupational Health and Safety Act obligations, how many of the recommendations are mandatory and how many are best practices?
Yeah, so in terms of if we're talking about the Act or the specific policies issued by the government, so under the Act, there's specific provisions which an employer must follow, and there's specific regulations which will apply to certain industries. So depending on what industry you're in, you may have certain obligations beyond just the Act. In terms of the specific, industry guidelines, they're guidelines. They're not necessarily form part of the Occupational Safety Act, which if you don't follow, you're going to be in violation. That being said, from a due diligence perspective, if you fail to follow specific government suggestions and something happens, you're likely going to have difficulty establishing that you've met due diligence in terms of providing a safe workplace. Now, every scenario, of course, is fact specific, but generally those recommendations are things you're going to want to put in place in your workplace to ensure that if something does happen, worst case, you have a due diligence defense.
Okay, great, thank you. So another question going back to IDEL and layoffs. What about the January 25th date with IDEL? You mentioned March as the start date, but doesn't it run back to January 25th?
No, the legislation itself says that it's deemed to be in effect Jan 25, but where it does the conversion, like it deems March 1st to be the first date of IDEL. So I'd have to dig in to see what other purpose the January 25th serves. So I apologize, I'm not off the top of my head, not sure, but the March 1st is the sort of the key deadline, the key start date on the IDEL.
Okay, and the last question we have, I think we talked a little bit about it in the presentation, but perhaps you could provide an overview. Can individuals that are considered high risk due to the medical reasons refuse to return to work and insist on continuing to work from home?
Well, I mean, and that's probably the perfect storm of difficult case to deal with, right? Because if they have a legitimate immunocompromised situation, and and they're productive working from home, then that might not be a fight you want to take on early. Maybe you do when things subside. If they're not productive or half productive, then and you don't have any cases of COVID at the workplace, then I think you could be a bit more aggressive on that and say, well, there are no cases here. And it's not like the person probably stays at home every minute of the day, so they may have just the same or more, frankly, of a risk if they of COVID contraction just being out in public. So it's really gonna, in that scenario, will really depend, and the key will be how productive the work from home is versus if there's any cases at the workplace.
I'll just add on to Sean's comments there. I think the digging into the medical documentation, the basis for the request is also relevant. For example, if the note simply says can't come back and require social distancing, well, can you facilitate a return to work where there is no interaction with our staff members? Is there off times? Is there other forms of accommodation beyond simply working from home? To Sean's point, I think the larger strategic question is that a fight you want to pick now? And maybe you do, given your workplace, but I think it's going to be a kind of a fact-specific medical documentation, reasons, and then workplace.
Okay, great. Well, you've answered all of our questions, so thank you very much for your time. I really want to thank both Seann and Evan for your time, sharing your time and your expertise with us today. To our attendees, as I mentioned, you will receive a follow-up email that will have a link to today's webinar, as well as a copy of the slides from today's webinar. And again, Seann and Evan, thanks so much for joining us today.
Thank you.
Thank you.